It is our finding that granting any of the relief sought in the petition as against parties whom the petitioners failed to sue would offend Article 50, Clause 1 of the Constitution and thereby create an illegality. This court cannot countenance that, and accordingly, we decline to issue any adverse orders sought against parties not sued in these proceedings. The prayers in the petition that seek those orders must necessarily be dismissed on that basis, and we hereby dismiss the same. The next issue is whether the IEBC selection panel acted illegally by issuing a subsequent expanded shortlist. It is the petitioner's case that Mr. Hassan Nur Hassan, the fifth interested party, was never shortlisted for the interviews and that he was only snuck in through an addendum shortlist, contrary to the selection and nomination process under the Independent Electoral and Boundaries Commission Act. The petitioners claim that the IEBC selection panel acted illegally and in a manner that discriminated against all other candidates. They contend that the inclusion and subsequent publication of the name of the fifth interested party during the course of the interviews, despite not having been initially shortlisted, was procedurally irregular and devoid of any lawful justification. In their view, this act contravened the principles of transparency, fairness, equality, and public participation as enshrined in Articles 10, 47, 232, and 250 of the Constitution, as well as Section 3 of the IEBC Act. The petitioners argue that the manner in which the process was conducted violated their legitimate expectation and that of the public at large, that the IEBC selection panel would at all times discharge its mandate in an open, accountable, and procedurally fair manner consistent with the constitutional and statutory framework governing appointments to independent commissions. On the part of the respondents, they contended that the fifth interested party was amongst the applicants in the long list who applied and was shortlisted for the interview for the position of Commissioner of IEBC, which interviews were held on 24th April 2025 at 12:30 p.m. and that the shortlist, as republished by the IEBC selection panel on 25th March 2025, was in accordance with paragraph 2 of the first schedule to the IEBC Act. In further response, the respondents and interested parties maintain that the selection process was conducted in strict conformity with the relevant constitutional and statutory provisions. They contend that the nomination of the fifth interested party was the product of a rigorous, competitive, and fair selection process undertaken in accordance with the established procedures and criteria. Accordingly, they reject the petitioner's assertions of procedural impropriety or constitutional breach and assert that the process met both the letter and spirit of the law governing public appointments to independent commissions. The question that we must answer from the rival positions above is whether the deviation from the original shortlist through the republication and adding of more names of applicants who were on the long list offended Articles 10, 27, 47, 232, and 250 of the Constitution, and the selection process under the IEBC Act and the Public Appointments Parliamentary Approval Act. Article 10 of the Constitution sets out the national values and principles of governance, which include transparency, accountability, non-discrimination, and inclusiveness. Article 27, Clause 1 guarantees equality before the law and equal protection and benefit of the law, while Article 47, Clause 1 secures every person's right to lawful, reasonable, and procedurally fair administrative action. Article 232, Clause 1 lays down the values and principles of public service, which include fair competition, merit-based appointments, transparency, and representation of Kenya's diverse communities. These principles are replicated in Chapter 6 of the Constitution and more specifically, Article 73 on responsibilities of leadership. We have carefully considered the sequence of events. On 5th March 2025, the IEBC selection panel published a long list of all applicants and a shortlist containing 92 persons, but excluding the fifth interested party. The fifth interested party was, however, number 985 of the long list, which is reproduced at page 230 of the petition. The total number of applicants was 1,356. Subsequently, on 25th March 2025, the IEBC selection panel republished the shortlist with 6 additional names, comprising the fifth interested party and 5 others. The name of the fifth interested party is number 4 of the interviews slated for 24th April 2025 at 12:30 p.m., and this is contained at page 325 of the petition. The expanded shortlist was accompanied by a public explanation, which is reproduced at page 320 of the petition, indicating that the revision of the shortlist was made to further enhance compliance with the constitutional principles of regional balance, representation of the youth, and overall inclusivity. The first schedule to the IEBC Act, at paragraph 5, empowers the selection panel to regulate its own procedure, provided that such procedure complies with the constitutional and statutory requirements. The petitioners referred us to paragraph 2 of the first schedule to the IEBC Act, which nonetheless makes no reference to any procedure to be adopted by the IEBC selection panel. Neither did the petitioners point out to this court any specific procedure which the IEBC selection panel allegedly failed to adhere to in their selection of the applicants. Notably, the republication occurred prior to the interview stage, and no previously shortlisted or long-listed candidate has come forward to allege prejudice or challenge the fairness of the process. There is also no evidence that the IEBC selection panel acted covertly or arbitrarily. Rather, it took an open, reasoned, and corrective step in alignment with its constitutional obligations. In our humble view, the discretion to revise a shortlist, as was exercised by the IEBC selection panel, in the absence of bad faith and for constitutionally justifiable reasons which they provided by way of an explanation in the republication, does not, per se, offend the law. We then cite cases in which the courts have dealt with previous similar concerns. We cite Trusted Society of Human Rights Alliance versus the Attorney General, High Court case 2012, the celebrated case of Mumo Matemu versus Trusted Society of Human Rights 2013, a Court of Appeal case, and also the case of Republic versus Judicial Service Commission, ex parte Pareno, a 2004 case, which reiterated that fairness and transparency are central to public appointments, but not every procedural irregularity amounts to a constitutional violation. I continue. On alleged breach of legitimate expectation of the petitioners and other candidate applicants, the doctrine of legitimate expectation was extensively considered by the Supreme Court in Communication Commission of Kenya and 5 others versus Royal Media Services and 5 others, 2014 case. It's a lengthy quotation. This court appreciates that any violation of constitutional values would vitiate the selection process. However, in this case, there was no evidence showing that the subsequent expanded shortlist was a substantive procedural deviation which violates rights and caused harm, and therefore, this court finds no constitutional violation. In our view, the principle of de minimis non curat lex, the law does not concern itself with trifles, applies in this case. This principle applies in constitutional interpretation that minor deviations do not cause substantive harm or infringe constitutional values are often not treated as violations that warrant judicial nullification. Accordingly, we find and hold that the republished shortlist did not offend Articles 10, 27, 47, or 232 of the Constitution. On the contrary, the IEBC selection panel's action, which was taken transparently and explained publicly, demonstrates a good faith effort to align the selection process with Kenya's constitutional ethos. We further find no evidence of violation of the principles of equality, fairness, or procedural justice. The next issue is familial relations of the fifth interested party with the leader of minority in the National Assembly. Apart from challenging the fifth interested party's selection and nomination on account of his having been shortlisted in the republished shortlist, on another front, the petitioners also contend that the fifth interested party admitted during his vetting by the National Assembly that he is the brother-in-law to the Member of Parliament for Suna East Constituency, Migori County, Honorable Junet Mohammed, who is also the current minority leader in the National Assembly. Consequently, it is the petitioner's case that the fifth interested party is not eligible for appointment as a member of the Commission and that he will not be impartial. The issue for determination is whether the alleged familial relationship between the fifth interested party and Honorable Junet Mohammed, the leader of minority in the National Assembly, is sufficient to create a reasonable apprehension in the mind of a fair-minded and informed member of the public that the said nominee may not exercise impartiality if appointed. It is further necessary to consider whether this alleged relationship was the sole or primary basis for the inclusion of the fifth interested party in the republished shortlist of nominees to the IEBC. It is public knowledge that this allegation was widely circulated in the media, with headlines such as, and we quote, "Godfathers have it," appearing in a publication dated Thursday, 5th June 2025 in one of the daily newspapers of nationwide circulation. Such reports had the effect of framing a narrative in the public domain that the nomination process was influenced by political patronage. Nevertheless, among all the nominees, it was only the fifth interested party whose familial connection to a senior political figure was specifically alleged. The fifth interested party, in his response, admitted to the existence of a familial relationship with the leader of minority in the National Assembly, saying that the latter was his brother-in-law. It is trite law that public appointments must adhere to the constitutional principles of integrity, fairness, merit, and transparency. These principles are entrenched in Articles 10, 27, 73, 232 of the Constitution, as well as the totality of Chapter 6 of the Constitution. Specifically, Article 73, 2A emphasizes that the guiding principle of leadership and integrity includes selection based on personal integrity, competence, and suitability. Additionally, Article 232, 1G requires fair competition and merit as key criteria in public service appointments. More importantly, Article 232 of the Constitution sets out the core values and principles that govern all public service in Kenya. The article mandates that public officers and institutions must uphold standards of professionalism and competence, ethical conduct and integrity, accountability and transparency, non-discrimination and equality, and efficient, effective, and responsive service delivery and the promotion of national values and unity. In essence, Article 232 ensures that the public service operates in a manner that is ethical, impartial, and dedicated to serving the public interest in accordance with constitutional values. These values and principles apply to state organs at both levels of government, as well as state corporations. On the other hand, Article 73 provides for responsibilities of leadership and makes it clear that leadership is a privilege and a responsibility to serve the people. The article mandates that state officers must be selected on the basis of personal integrity, competence and suitability, and not on connections or influence. Further, public trust demands that decisions, including appointments, be made objectively, impartially, and in the public interest. It follows that state officers must avoid nepotism, favoritism, or conduct that undermines integrity and public confidence. Article 73 calls on state officers to avoid any conflict between personal interests and public duties. The Leadership and Integrity Act 2012 operationalizes Chapter 6 of the Constitution, and specifically, it requires that appointments to state offices must be transparent and based on merit. Nominees must demonstrate integrity, competence, and ethical conduct, and a person with a history or a risk of conflict of interest and who cannot serve independently should not be appointed. Thus, an appointment that appears to serve personal, familial, or political interests may be challenged under these provisions, and therefore it is for this reason that state officers should not place themselves in positions where they might be influenced by relationships or loyalties that compromise impartiality. Furthermore, while the existence of a familial relationship between a nominee and a politician is not in itself a legal bar to appointment, such connection cannot be ignored where it gives rise to a reasonable perception of partiality, undue influence, or political patronage. Public office is held in trust for the people, and the perception of independence and impartiality is as vital as the reality. That said, the Constitution does not impose a blanket prohibition against individuals related to politicians from holding public office. Doing so would risk violating the right to equal opportunity and the principle of merit-based appointments, unless such appointment would raise reasonable apprehension of bias in the minds of a reasonable and informed person. The proper approach is a contextual and case-specific evaluation that considers whether the nominee has demonstrated a track record of independence, professionalism, and transparency regarding the relationship, and whether institutional safeguards against conflict of interest are in place, and whether their appointment would undermine or would conversely reinforce public confidence in the appointing institution. It is this balance between safeguarding institutional integrity and ensuring fair access to public service that the Constitution seeks to uphold. We then quote the Court of Appeal while dealing with the doctrine of bias in the case of Wanjigi versus Chebukati, 2022. It's a lengthy quote, I will not read it in full. In this case, the fifth interested party did not deny the fact that he is the brother-in-law to Honorable Junet Mohammed. The question is whether that was the sole basis for his being selected, shortlisted, and nominated as a proposed member of the IEBC. As we answer this question, we observe that the petitioners have not impeached the fifth interested party's professional qualifications, and neither have they said that he is wanting in integrity. Save for the alleged disqualification under Article 88, 2A1, which is addressed elsewhere in this judgment, the petitioners have not challenged the fifth interested party's overall suitability for appointment as a commissioner of the IEBC. Therefore, while perceived conflicts of interest, nepotism, and bias are legitimate public concerns, they must be grounded in evidence of procedural breach, bias, or influence. Where none of these features exist, and where a candidate has undergone a transparent and competitive process, has been interviewed, vetted, and found to be competent and meeting all other set criteria, family relations alone cannot be a constitutional disqualifier. To hold otherwise would effectively impose an extra constitutional bar based on association, thus offending the principles of equality and dignity of opportunity, particularly where merit has been established. The Court of Appeal in Gachagua and 5 others versus Maingi and 80 others, Civil Appeal number E829 of 2024, consolidated with others, dealt with these very concerns of familial relations. The Superior Court had this to say concerning allegations of bias on account of familial relations, addressing the issue of whether the judges in the High Court should have recused themselves from hearing the case of the impeachment of the Deputy President of the Republic of Kenya, a principle which we find is relevant to the instant petition. It's lengthy. Let me read it from paragraph 197 of that. We fully endorse the findings of the High Court that family members of judges are entitled to pursue independent careers, and such pursuits in of themselves should not cast doubt on a judge's impartiality. Family members of judges, like any other qualified Kenyan, can lawfully be appointed to any public office, and that, per se, cannot be a ground for a judge's recusal, unless it is demonstrated that the appointment was intended to give the appointing authority an undue advantage in judicial proceedings, or for any other improper factor relating to the appointment and the judge's discharge of judicial duties. To suggest otherwise would impose an unreasonable and disproportionate burden on judges and judicial officers. The professional undertakings of a judge's spouse, particularly where they bear no direct relevance to the matter before the court, cannot serve as a valid basis to question the judge's objectivity. In the absence of specific and compelling evidence of a conflict of interest, such allegations amount to mere speculation and fail to meet the requisite legal standard for recusal. End of quote. In this case, we find that the petitioners have not discharged the legal burden of proving the nominee's relation with a top politician influenced the nomination of the fifth interested party, or that he will not be impartial in the discharge of his mandate as a member of IEBC. We then quote the case of Evans Nyakwana versus Cleophas Bwana Ongaro, a 2015 case. Consequently, we find that in the absence of undue influence, interference, or irregularity in the process, the fifth interested party's familial relationship to a political actor or public official cannot, without more, invalidate or negate his selection, nomination, and possible appointment to serve as a member of the IEBC, which is a state office, provided that the selection, nomination, and possible appointment satisfies all other constitutional and statutory requirements. We therefore reject the invitation by the petitioners to declare the fifth interested party ineligible for nomination and appointment as an IEBC commissioner on account of familial relations with a serving politician.